This is CPLR 3012-8, Certificate of Merit in Medical, Dental, and Podiatric Malpractice Actions. Okay? So in medical, dental, and podiatric actions, complaint shall be accompanied by a certificate executed by the attorney for plaintiff. Okay, a pro se does not need this. This is only if the plaintiff is represented by an attorney. It basically says that the attorney consulted with at least one of these professionals, okay, in the practice area, whether it's medical, dental, or podiatric, who is licensed to practice in the state, okay, and the conclusion gives reasonable basis for commencement of an action. So basically, the attorney is going to consult with the professional, and he's able to produce this certificate that said, hey, I consulted with this professional, and they're saying, yeah, there is reason to believe that, this is a legit, case. Like, we can do a case on this. All right. 2. Limited time attorney files certification within 90 days after service of complaint. So this is where the attorney did not have time to consult someone. So he's going to file the complaint, but then within 90 days, he says he's going to do the consultation and produce the certificate. Okay? 3, attorney, after making 3 good faith separate attempts to obtain consultation, none would agree to consultation. So basically what he's saying is that he made 3 attempts to get in touch with somebody, but none of them would do the consultation regarding the case. Okay? B, more than one defendant only, one certificate needs to be filed. So if there's more than one defendant in the case, he doesn't have to do a certificate for each defendant. One is good enough. C, attorney relying on ipsa loquitor. Okay? I looked that shit up. I wasn't gonna go like that. I don't play. So the thing speaks for itself. So what they're trying to say with this ipsa loquitor is that this injury or whatever happened, look at it. I don't need to have a professional. Even like Joe Schmo without a license can tell this is a legit case. So that's what the attorney is going to rely on. He's not going to do the certificate. He's going to say, yo, this thing speaks for itself. Ipsa loquitur. Okay? So this is based on circumstantial evidence as burden of proof. So it does not need the certificate. Okay, then we got D, records requested by plaintiff not produced, have 90 days to file certificate after production of records. So basically what they're saying is that the plaintiff requested these records and he has not received them. Okay, so once he receives those records, he has 90 days to file the certification. I feel like I had another card on this one. Let me check real quick. I do. All right, it's just a question card, but let's do it. Okay, so this is CPLR 3012-A. When does attorney have to provide names of medical, dental, or podiatric professional with whom the attorney consulted with? The answer is, the court may, upon request of a defendant made prior to compliance by plaintiff, require the attorney to divulge to the court names of physician, dentist, or podiatric refusing such consultation. So basically the defendant is saying, I don't believe that he even consulted. I want to know who he consulted with. So it's like proving that he's not just saying that he consulted with these people, but they want the names. And the defendant gets this going. Okay? And that is CPLR 3012-A.